Hi, everyone. Welcome back to Eagle Forum's Capitol Hill Update. My name is Tabitha Walter, and I'm the Political Director of Eagle Forum.
And I'm Kirsten Hassler, our Executive Director. Today, we're going to give you an update on one of those legislative items that just doesn't seem to go away, and that's the Equal Rights Amendment. So you remember last year that we asked for your help in advocating against a resolution that would remove the ratification deadline from the Equal Rights Amendment. And sadly, that did end up passing the House of Representatives. Now, this same resolution is back this Congress. So why can't Congress simply legislate away the ERA's ratification deadline? Well, to answer that, it's really helpful to have some background.
All right, here we go. The ERA moved through Congress originally in 1971. In 1972, amendments were proposed to prevent the ERA from taking away traditional rights and benefits from women. These were defeated, and the ERA maintained its original and rigid language. So Congress sent the ERA to the states on March 22nd, 1972. A total of 38 states were needed to approve the amendment within a 7-year time frame. But only 35 states passed the ERA, and 5 states chose to rescind their ratifications. Those 5 states were Nebraska, Tennessee, Idaho, Kentucky, and South Dakota. Then the Supreme Court ruled in 1982, what the case was Now versus Idaho. Now is the National Organization for Women, I believe. That the ERA failed ratification. And then since then, ERA activists have continued their efforts and claimed that Virginia was the last state needed to ratify.
And more recently, the DOJ in January of 2020 came out and said that, quote, Congress may not revive a proposed amendment after a deadline for its ratification has expired. Should Congress wish to propose the amendment anew, it may do so through the same procedures required to propose an amendment in the first instance, consistent with Article 5 of the Constitution, end quote. And even Justice Ruth Bader Ginsburg has told supporters that the process to ratify the ERA must start over.
But the ERA has very bad policy implications for us women. In both New Mexico and Connecticut, state ERAs were used to overturn abortion restrictions and mandate taxpayer funding of abortion. So those were ERAs that were passed in state legislatures, not on the federal scale. So you may have an ERA in your state that you could look into trying to fight to rescind it. But make no mistake, a federal ERA will give the abortion business exactly what they want, abortion on demand. And to add to this, by removing gender distinctions, the ERA will violate women's privacy and laws intended only for women, like Title IX.
And we'll be tracking the ERA's progress through both chambers. So please make sure that you are signed up to receive our legislative action alerts so that when the time comes and we do need your help, you are there to help us answer. If you have any questions about today's report, please feel free to post them below. We'll be back next week right here at 2 p.m. Eastern. See you then.
See ya.